Hi, everyone. This is Anisha Gandhi. Welcome to part 2 of representing LGBT asylum seekers, and we'll be talking about preparing and presenting your case. Again, my name is Anisha. I'm the managing attorney of NIJC's LGBT Immigrant Rights Initiative, and along with me today is my colleagues Tania Linares Garcia and Michelle Velasquez, who also joined me on Tuesday, and they will also be presenting today. As I mentioned on Tuesday, we do the majority of our pro bono support at NIJC's LGBT Immigrant Rights Initiative. So if you have a case with us already, always feel free to reach out to us with any questions or concerns you may have. Just a couple housekeeping items for those who weren't here during our part 1 of our training on Tuesday. You can type in questions on the right-hand side and we'll answer them as we go. If we do have time at the end or during, we may step in and answer some questions, but it just kind of depends on the timing and the types of questions we're receiving. You'll also see on the right 2 documents that we've uploaded. One you've already seen, which is the Pro Bono Asylum Manual, but feel free to download that. And then a PDF of the slides that we're going through right now is also there. We're so excited that so many people have signed up. This training is intended for attorneys, and so for those who are not attorneys, please be mindful about the unauthorized practice of law. And lastly, for CLEs, it's just a friendly reminder that attorneys in Illinois who are requesting CLEs need to make sure we have their ARDC numbers. And if you didn't include that in your registration, you need to email that to us. We will email certificates to all participants after the webinar, and attorneys licensed in other states, I believe you can use the certificate to request CLE from their bar, from your specific state. And just one last thing, I want to thank everyone for taking the time to learn more about representing LGBT asylum seekers. We're really thrilled at the level of interest. This is not only important because it is Pride Month, but because our LGBT migrant community suffers harm at a disproportionate rate in the systems they encounter during their journey to the United States and also once they are here. And so it's important that we work to support and protect our community members through this arduous process. So I just want to thank you all for taking that step. All right, let's get started. On to the next slide. So for those who have already joined us, this is going to be a little repetitive, but NIJC is an agency of Heartland Alliance. We're probably the only legal service provider within Heartland. We provide all aspects of immigration legal representation outside of employment-based immigration, like student visas and tourist visas, student and tourist visas. And on average, we provide legal services to 10,000 plus immigrants, refugees, and asylum seekers, and that's each year. We provide this representation in detention to unaccompanied children, to victims of crimes, family-based petitions, and of course, asylum seekers. And what's unique about NIJC is that we not only provide broad-based, high-volume legal representation, but we also provide broad-based, high-volume, high-impact litigation and advocacy and policy work. And we believe this is critical to our work because we are able to build off the information that we learn from our direct representation work and then use that information to further our impact litigation and policy work. So everything kind of works together. NIJC now operates with 5 offices across the country and a dedicated staff of 120 with support of nearly 2,100 pro bono attorneys that are actively working on cases right now. So next slide. Again, why it's important to be a pro bono attorney. Non-citizens do not have the right to appointed counsel, but are 5 times more likely to obtain relief if they do have counsel. So, if you're interested in other types of pro bono work that we may do at NIJC, feel free to reach out to us and we can provide that information. You can also find it on our website. A little bit more about how a client comes to us. They get in contact with one of NIJC's offices, whether that be in Chicago, Indiana, San Diego. They come to us through the connections in community or through word of mouth, through our detention hotline or LGBT hotline, and then often through our help desk at the immigration court when it's open in Chicago. We then conduct an in-depth case screening and assessment of their case. And for NIJC's LGBT project specifically, we are looking for whether they are income eligible for our services. And then do they have a viable case based on what has happened to them in home country and where they are from. And we also look to see if it is a good case for pro bono representation or whether we need to keep the case in-house. If the case is accepted, NIJC assigns a retainer with the client and begins to look for pro bono placement. So this means that we agree to represent an individual even if we are unable to find pro bono representation. And then once a pro bono team accepts the case, NIJC remains of counsel and provides attorney support, document review, technical assistance, and this is throughout the life of the case. However, the case does mainly become that of the pro bono team, and you will be meeting with the clients, working on the filings. You're going to be the one to go to the interview at the asylum office or to hearings in front of the immigration court. So just a little bit of context for how we work with pro bonos. Next slide. And then, we realize that many of our pro bonos are still learning about the immigration system for the first time, which is totally okay. And so we're here to support you throughout, again, the life of the case. We have on our website and attached in documents our asylum manual, which walks you through the law, as I mentioned before, but it even explains the process from the minute you take the case till the end of it. You can also find on our website recordings, recorded trainings, frequently asked questions, practice advisories, and you can always reach out to your NIJC contact and to access, sample briefs, cover letters. In the LGBT asylum cases, we keep up-to-date country conditions, are always willing to share those with you. And of course, then to ask questions or raise concerns around interpreters, your judge, or anything else that may pop up. Next slide. So we're briefly going to hear from one of our longtime supporters, Jeremy Gray, who has worked on a number of asylum cases, including several LGBT asylum cases, both for detained and non-detained individuals. He is a partner at Jones Day and a board member of the Lesbian and Gay Bar Association of Chicago. So let's hear from him now about his experience representing LGBT asylum seekers. A lot of what he'll talk about during his video will be discussed more today during our presentation. So go ahead and start that video.
I've had the good fortune to represent a number of LGBTQ asylum seekers over the past few years. One of the more challenging aspects of preparing LGBTQ asylum cases is developing trust between you and your client. Many, if not most, LGBTQ asylum seekers are fleeing environments where they are unable to be out, and many have lived in constant fear of societal shunning and life-threatening injuries just because of their sexual orientation or gender identity. And many LGBTQ asylum seekers do not have significant support systems in their home countries. Many have been disowned by their families, and many have been deprived of the ability to operate in normal society, such as, for example, working in mainstream businesses. It can sometimes take weeks or even months for your client to open up and let you know what it was like where they are from and really what they are fleeing from, what they are fleeing. But this, trust is important because the persecution they are fleeing is often severe and can involve psychologically traumatic events. And it's critical that you learn the full extent of your client's circumstances and be able to work with them to go through each of these events in excruciating detail to explain what happened. My biggest recommendation is that you prepare yourself for these stories because they are never easy to hear, and they can involve a whole array of actions, including severe beatings, and sometimes sexual assault. But you have to try to find ways to help your client be able to explain these events and also be aware of ways of helping your client, including also their case, by securing such things as psychological or medical help. But in the end, even with all of these traumatic events, when you're able to establish that trust and your client begins to confide in you, you are able to immensely help build their case and ultimately be a better advocate for them. Now, one of the more odd aspects of preparing LGBTQ asylum cases is having to prepare your client to effectively prove up that they are a member of the LGBTQ community. And this has to happen not only in the filings, but also in front of the court. This means that you have to prepare your client to discuss their most intimate connections, whether those be boyfriends or girlfriends or partners, and sometimes even having to discuss their sex lives, and sometimes even in detail. When I represented my first LGBTQ identifying client, I remember initially feeling shy about asking some of these questions. I would think to myself, how would I feel if I had been asked these same things? And in the end, it has to be done. And sometimes you also have to find ways to corroborate these accounts. And maybe that requires getting an affidavit from an ex-partner or getting an affidavit from a family member that has shunned your client or because they disagree with your client's identification as a LGBTQ individual. But again, this is where trust is really critical, and being able to explain to your client and help them understand that what you really want for them is to have the best opportunity to be able to start again in a new and safer place. Now, in the end, the impact we can have on the lives of LGBTQ asylum seekers is immense. I still recall the time I had the honor to represent a lesbian woman from Central America who had suffered immensely in her home country and ultimately decided to take the perilous journey to the United States. Recently, she reached back out to us to let us know how she was doing, and she told us how happy she was living in the United States and how she finally felt free and how she was able to walk down the street holding her new girlfriend's hand without fear that she would be physically assaulted for doing so. And that was something she could never do in her home country. Those are the stories that will be with you forever. Thank you.
I hope a lot of you could hear that. I understand that for some it was not working, but hopefully you could see and hear that. And next slide, please. So just briefly to clarify, earlier I said that country conditions were available. I think I said for the LGBT cases, but just to be very clear, it is just for LGBT cases. We're able to keep those up to date. We do that in order to help support pro se individuals who are often detained in remote areas. So that's how the project of keeping country conditions updated started. And because we have those updated, we also share them with pro bonos. Again, being clear that tailoring those country conditions is really important, which we'll get a little bit into moving forward. So our agenda today is preparing your case, which Tanya will be speaking about, and then representing your LGBT asylum seeker, which Michelle will be doing, and then I will end with presenting your case. So I'll turn it over to Tanya. Thank you.
Hey y'all, so in this section we're going to talk about and walk through the process of what happens from the moment you take a referral from NIJC to filing. And if we go to the next slide, we before you even start looking at the file and reviewing the case, there's just something we wanted to flag for you, right? And like, and that is, how do we know for sure, or how do we make sure that our client is or is not in removal proceedings? And just as a reminder from our last session, whether your client is in removal proceedings will determine who has jurisdiction over their case, meaning whether you have to file before the asylum office or whether you have to file before the immigration court. And the document that you will see on your screen, the notice to appear, is the charging document in immigration proceedings. That's the document that initiates removal proceedings against a person, but only when it is filed with the court. So it is not enough that your client got a copy of a notice to appear if that was never filed with the court. And to figure out whether the NTA, as we refer to the notice to appear, has been filed, you can call the EOIR hotline, or you can call the immigration court that would have jurisdiction over the case. If either of those systems or both of those systems tell you that your client's information is not in the system, then it's safe to assume that the NTA was never filed with the court and your client is not in removal proceedings. If you have any questions, or if your client does have an NTA but you don't know what happened, it's always best to double check with your NIJC point of contact. But as just as a general rule, we would assume that that person is not in removal proceedings. So if we go to the next slide, then we can start looking at what happens once you take a case, and a few steps that you should take immediately upon taking a case with NIJC, right? The first, just review the NIJC file. We will include our intake notes and any documents we've gathered from the clients. And that will give you a great starting point to understand, one, what the case is about, and two, like, essentially know what you have and what you don't have, right? And from there, determine what the next steps should be. Once you've reviewed the file, again, just double check that the NTA has been filed with the court and that your client's actually in removal proceedings, if that's the procedural posture that you understand the case to be in. And then if your client is in removal proceedings, then file your appearance with the court. Now, entering your appearance is a two-step process. The first step you do online. The second step actually requires you to go in person to the immigration court with some form of photo ID. And once you complete the second step, it can take up to 24 hours to get your EOIR attorney number. So it's important for you to complete this process well in advance of your next hearing. Otherwise, you may not have an EOIR number and may be unable to enter your appearance at that court date. So once you've filed your appearance and you have a good sense of the case, then as you're reviewing the file, make sure that you calendar all the important dates in the case, right? That would be the 1 year filing deadline. That means a year from when your client last entered the United States. As you remember from our last session, missing that deadline could be a bar to asylum. So it's very important to have that flag. Again, this will be a lot less likely to happen if your client is detained, but it's still important to be aware of that date in case there's some unexpected delays in the case. And also for clients who are not detained, especially, we want to mark the date when we can start applying for employment authorization for them. Right now, that requires 150 days from the filing of the asylum application. So once you file the asylum application, just make sure that you count 150 days from that and you mark that on your calendar so that we can apply for work authorization as soon as we can. So if we go to the next slide, then we'll have a chart of what all needs to be filed either before the asylum office or before the immigration court. You know, the procedures and formatting is a little bit different in each of them. We do have this checklist in the manual, so don't worry about trying to memorize it. You will have that available to you. But we will be focusing on the last part of that checklist, right? Which is the memo or brief, the declarations, and corroborating evidence, which is fairly the same for both affirmative and defensive asylum cases. One thing I will note here, if you look at the appearance line, both on the affirmative and defensive side columns, you will note that to enter your appearance before the immigration court, you will need an E-28 form. And to enter your appearance before the asylum office, you will need a G-28 form. One thing I want to add to that is the G-28 form is actually used to enter your appearance before any sub-agency of the Department of Homeland Security. So, for instance, if your client is detained, you may also want to get a signature, or you will also want to get a signature for a G-28, because that's the form that's going to allow you to talk to ICE about your client's detention and release. So if we go to the next slide then, once you have reviewed the file, you have a sense of what all you will need to prepare for the case, then you're ready to start actually making steps towards preparing the case. And of course, one of the first things you should do is get in touch with your client, schedule a meeting with them. And, this first meeting should be about introductions, about building rapport. Often our clients will come to their first meeting with family or friends and, expect the family or friends to come into the meeting with them. I think if you feel comfortable with it, I think it's often helpful to meet the family, meet their support systems. But then after introductions, we would ask the family or friends to step outside. And then we can talk in a little bit more detail with our clients about confidentiality and why it's important for us to meet with them without anybody else present, right? And that's both confidentiality, but also to create a space for them to feel safe and free to talk about their history or harm or pretty sensitive topics. As you do this, something that has been helpful for me is to also, one, give a roadmap of what we can expect the process to be like, but two, while you're given that roadmap, also explain to your client both what the expectations are and how we're going to work through them, right? So, I think being upfront about the fact that they will have to talk about their history of harm in a lot of detail and sometimes even more than once, it's good to flag that so that they can just start mentally preparing themselves. But also you can use this opportunity to talk about what would work for them when things get tough, right? Like sometimes I will say, okay, we're gonna have to talk about some things. If you ever feel like it's becoming too much, just tell me to pause. We can pause. We can, shorten the meetings. Let's work on what works for you and what makes this process most helpful to you. And also during this first meeting, particularly for LGBT clients, it's a great way to start building a rapport and creating a sense of safety, right? A few of the things that you can do, and I know Michelle's going to talk a little bit more about this later, is reaffirming, asking what names they want you to use for them, asking what their pronouns are. Often a good way of starting this is just by introducing yourself and affirmatively saying what pronouns you use. And that gives you a little bit more of an opening for them to feel safe to do the same. And then once you go through the first meeting, you can start gathering more about your client's immigration history, any other previous proceedings that they have had. Make sure that we have the files for that you listen to the hearings, or get a better sense of what all has happened in any encounter that they have previously had with immigration authorities. Sometimes if your client has a complicated immigration history, or there's just a lot of things that they don't remember or they don't really know about, it would be helpful to file a FOIA request right away, in the hopes that we can get that information before we have to file. And then once you have talked to your clients a couple times and you have a good sense of the immigration history, then you can start working on a skeletal asylum application. Now, I think we have to be aware that generally we file those applications pretty early on in the process, at least for defensive filings. And so there may be things that you don't entirely understand yet. There may be factual things that you think you understand, and then upon talking to your client a lot more, you figure out that you had the chronology wrong, or you misunderstood the facts. So it's helpful to leave the application fairly skeletal, right? You have to provide enough information for the judge to understand the grounds of the asylum claim, but not so much information that you would tie yourself to facts that you may not completely understand, right? So, for instance, if you're talking about the past harm that your client suffered, you can say, yes, I suffered, beatings and the emotional abuse throughout my life, and then I would leave it at like a sentence or two more beyond that, but I wouldn't start talking about dates or any specifics. And then once you file that skeletal application, then you can start working on the rest of the claim. So we can go to the next slide. And as I mentioned before, we're going to be focusing on 3 parts of the filing, right? That are really the substantive parts of the filing. Your client's declaration, the corroborating evidence, and the legal document, and the legal argument, which is the brief or the memo. Now, as you're working through them, you really should keep an eye out on all of these parts while you're working through each of them, right? So you don't have to wait until you finish one to start another, but you should essentially keep track of what all you're saying on one end, how that applies to the legal elements, and how you can corroborate your client's story. So for example, say you start reviewing the intake notes, you have a good idea of the grounds of the asylum claim, and you essentially by now know what you know and what you don't know. So I would use that as a template to guide the first few conversations with your client, get a better understanding of what happened, when it happened, and things like that, right? I like to write out my notes, like transcribe the intake notes chronologically, and then figure out where there's spaces or where there's gaps, and whether I actually understand that chronology correctly. And then also, as you start talking to your client and you're starting to fill the gaps on the declaration and on their story, you'll start getting a sense of what corroborating evidence could be available. So for instance, if your client is talking about one of their incidents of harm and they say they were attacked in front of their cousin, right? I think the next thought you should have is, and the next questions you should ask is whether they're still in touch with their cousin, whether their cousin is someone we could reach, and whether they would be willing to provide a statement about the attack that they witnessed, right? But also, as you talk to your clients more, you may you also want to keep an eye out for the elements and the bars to asylum, right? So sometimes as you start preparing your case and talking to your clients, they'll disclose past criminal histories that we were unaware of, right? And that could be a bar to asylum. So it's important to keep an eye out on what those could be and how they can affect their eligibility, and delve deeper into those facts once they come to light. Another example of this is sometimes clients, as we're working through their case, disclose that they've had a history of psychiatric conditions. And, once we realize that, we also have to think about the legal argument and how it changes, because those conditions can affect their competency or may require us to seek safeguards so that they can actually participate in the proceedings and actually understand what is going on. And also because those conditions may give rise to independent claims for asylum. So it's important to keep track, again, of all the legal elements of anything that could bring out other claims for asylum or or other bars. So if we go to the next slide, then we can talk a little bit more about how to start working on an affidavit. Now, one thing to remember is that often our clients have been are trauma survivors, and we have to keep that in mind as we're working through them. I've talked a little bit about the importance of creating a safe space for them. And this goes throughout the proceedings, right? Throughout the preparation of the case. One thing that's important to understand is that the seller's advocacy that we want to present in court really starts with preparing the case. And it's really, as a pro bono attorney, one of your jobs is to give agency to your client, and within a system that is often dehumanizing, and it increasingly has been weaponized to deter people from actually seeking refuge here. So how we go about understanding their story and how we present their story goes a long way into creating a space where they can feel safe, right? Or as safe as you can be when you have to talk about these things in front of a court. So a few of the things that we can do, talk to your clients frequently, particularly if they're in detention. For our clients who are detained, I generally talk to them, or try to talk to them, about once a week as we're preparing their case, even if I'm not ready to keep working on the affidavit, just to check in on how they're doing. Again, it's very important to give your client agency over the choices, the options they have for their case, how they want to present their case. There may be something that you think would be helpful to them that they're just absolutely not comfortable with sharing, and trying to work with them through that and understanding why they are not comfortable and how you can help them get there is important. But also, if they ultimately just absolutely cannot talk about something, I think we also, you may want to talk to your NIJC point of contact for a little bit more guidance on that. But we don't want to present a case that our clients would not feel that would further dehumanize our clients, right? And one of the things that I have found most useful is also to bookend an interview, right? Particularly for detained clients, I always start talking to them about how they're doing, how things are going in the detention center, just get a sense of where they are emotionally and mentally that day, and then start talking about the substantive parts of the case. But also acknowledging that often the conversations you're going to have with your clients are very heavy. So making some time at the end of a meeting or of a phone call to check in on them, check in how they're doing, and just making sure that, you know, even doing some small talk or talking about things that are not as tough would be helpful to leave them in a good space before you hang up or before they leave the office. So if we go to the next slide, then we can go a little bit into more of the substantive parts of writing a declaration. As we mentioned before in our last session, credibility is one of the most important parts, if not the most important part of an asylum case, right? If your client is found not credible, none of their past harm is going to be credited, and it will also preclude them from establishing a future fear of persecution or torture, right? That could be based on a number of things. One of the biggest ones, of course, is internal inconsistencies between your client's declaration, testimony, and the corroborating evidence. But it could also be based on how your client acts during a hearing, right? So, which again goes back to the need to prepare your client throughout the process and to build reports so that they don't feel like they are alone when they are testifying. One of the things that we want to make sure to do in a declaration is to cover the where, when, how, why, and who, right? All of the big questions as to all of the factual elements of the claim, right? So for every incidence of harm, make sure you're answering all of those questions. Make sure you're giving context. But also you have to balance the detail, right? You don't want to have a 30, 40 page declaration. You want to cut it out at about 12 pages or 15. It depends on the case, right? But you want to balance the detail. You want to balance the length of the declaration. And a few things to look for in drafting an affidavit. One is the language that you're using, and we're going to go into a little bit more detail about that in a second. Two, as I mentioned before, just give enough context and give enough background to understand the story you're telling. Three, keep an eye on the asylum elements, right? Make sure that you're meeting all of the asylum elements through your storytelling. Meaning, you have to prove that the harm was severe enough, right? So you have to go a little bit more in detail as to, for instance, if your client was physically attacked, what that entailed. Like, did they need medical help after? Like, how much medical help did they need? Like, what happened in the days following? And things like that. Did they have any permanent scarring or any other kind of like permanent effects from the beating, right? But you also have to prove that that beating was on account of a protected ground, right? Their sexual orientation or the gender identity. So you have to develop that in the story, right? Did the attacker say something that would lead you to believe that it was on account of their sexual orientation during the beating? Did the attackers do something before or after that, again, provides circumstantial evidence? Make sure to develop all of those facts through the affidavit. And then lastly, another thing to look for is just making sure that every part of your case, including your client's declaration, is internally consistent with other documents. So for instance, if your client is telling you that, you know, they were attacked right outside of their house, and then you have another declaration from a family member that says, actually, they were attacked down the street. It doesn't seem like a big difference, but you do want to resolve that sort of inconsistency because, again, anything that is inconsistent can be used to find your client not credible. So if we go to the next slide. We can talk a little bit more about the language and how you want to frame your client's declaration. So we have some examples here. I think the one that we see most often as we're reviewing declarations is the example with too much legalese, right? There's this default to just want to say the elements out loud as you're telling the story. Right, so here, when I told them I did not want to join their gang, they became more menacing. That is probably not the words that the client used. Some clients do use those words, and that's great. But if that is not how your client is telling the story, just make sure that it doesn't sound like an attorney wrote it, right? Again, I was persecuted because I belong to the group of Salvadoran females in relationships they cannot leave. Is probably not how your client perceives their case to be. So just making sure that it's in your client's voice. And to the extent possible, we try to avoid like very specific dates, right? So on May 1st, 2010, you know, as we mentioned before, often our clients are survivors of trauma, and trauma does affect memory. And also just even if it's not a traumatic event, I don't know how many of us remember what we were doing on May 1st, 2010, but, you know, often as we're working with clients, we realize that they may not remember the dates as well as they think, or that they're just telling us dates because they felt like we were asking for them. So to the extent possible, just be a little bit more vague than that, right? Like, in 2010, or when I was 19 years old, or when I was about 16, or when I was in high school, right? Just something that is going to be easier for your client to track than a specific date. So next, we can talk a little bit more about corroboration, which is the other part of the evidence that you are providing, and that's on the next slide. So again, it's important that you don't start working on corroboration right before filing or right when you have the affidavit ready. You need to keep in mind and start working through the corroboration as you're working through the case. There's multiple reasons for that. One is often we have to get in touch or track down documents that are outside of the US, and how long that's going to take and what we're going to be able to get really varies case by case. So it's important that, you know, we can at least tell the judge that we made our very best effort to get a document and explain what all we did, as opposed to thinking about getting something a week before filing and, you know, not making as much of an effort. And this is because corroboration, while credible testimony may be sufficient to establish an asylum claim, corroboration is may be required unless it could not be reasonably obtained. So even if we cannot get every piece of evidence that we can think of, if we can at least demonstrate that we made a good faith effort to try to find that evidence, and for instance, we're never able to get in touch with family, or the documents got lost in the mail or something, like as long as we are able to say why we could not get the corroboration, that's still better than not really making that effort. And again, you want to corroborate every element. So, and we're going to talk in more detail on the next slide. So if we can go to the next slide. This is a helpful chart. I think for me, it's helpful to break it into different contexts, right? Who is your client? And you can prove that through identity documents. You can also into the who is your client corroboration of like sexual orientation or gender identity or political opinion, which can come in many forms, right? Be it from declarations of friends or family members, or you know, sometimes our clients bring pictures of them like organizing for like either for like LGBT rights, or just like organizing and like according to their political opinion and things like that. Really just at a very broadest level, who is this person, and how are they a part of the particular social group that they are requesting asylum under, right? And then the next context that I would look at is what's going on in the country. And we prove that through the country conditions evidence, expert reports, maybe even declarations from both your client and like family members or friends who can explain what all is happening in the country and why that country is dangerous to your client or people who are similarly situated. Then the next point is what has already happened to your client, right? What is their history of harm? And again, this can be proved in a number of ways, via declarations, it could be photographs, it could be news reports, given anything that you can think of that can corroborate any incident or all incidents of harm for your client. The fourth category that I like to think of is how has the harm affected your client? Meaning what if any are the corroborating evidence of the results of an incidence of harm. So that could include like forensic reports, that could include psychological evaluations, that could include also both your client's declaration and declarations from friends, family, people who saw them go through this history of harm and can explain, even if they did not see it happen, what changes they saw in your client or how that had affected your client. And then lastly, what is likely to happen to your client if they were to return? And we can explain that again through a variety of evidence, including affidavits from people who are still in the country, proof of harm to others who are similarly situated, be it people your client knows or like the community that they belong to, or also country conditions, right? For something that's important to note about corroboration, for documents that you are receiving from the home country, or any piece of primary evidence that you're getting, you must establish a chain of custody. Meaning you have to also provide some sort of declaration or be able to account for how you received it and who sent it to you and how they came to have that piece of evidence. And if you receive a primary piece of evidence that, and you're doubting its authenticity, I think generally what we try to do is we generally, if we have serious questions about its authenticity, we leave it out. But I would recommend that you talk to your NIJC point of contact so that you can discuss in more detail. And a few more things, any document that is not in English has to be translated, and we have to provide a certificate of translation. Generally, we don't have attorneys sign those certificates, but we can have like paralegals or anyone who's not the attorney of record in the case sign those certificates of translation. And as Anisha noted, we do have country conditions evidence, and we also have country conditions annotated, an annotated index. I would also encourage you to add the corroborating evidence to the annotated index, along with the country conditions, right? So if you have declarations and or primary evidence, just add it and annotate it to the index so that you can have, so that the judge can have a sense of all of the evidence that is available through the index. So if we go to the next slide, we can talk a little bit more about the legal argument. So while it is true that you should keep an eye on the declaration, the corroborating evidence, and the legal arguments, just keep an eye on all of that throughout the preparation of the case. I generally don't start writing or like drafting a memo or a brief until my evidence is almost final, right? And that is because the brief is really what you use to tie all of your evidence into a legal argument, right? It's your best way to utilize all of the evidence. So make sure that if you're putting something into the index, it's because you're going to use it in your legal argument. There really are very few instances where you are adding something to the record and not using it in the brief. And also because you have to have a good understanding of the facts by the time you start writing the brief. I feel like it makes it a lot faster if you have a good sense of what all of your declarations say and all of your corroborating evidence say. Really, you can just start drafting, marshal all of the facts, and then, frankly, I do the citations at the end, just to make sure that everything is there. But it's a lot easier to write the brief once you have a better understanding of the facts. So lastly, if we go to the next slide, we can talk about the filing format, right? And as I mentioned before, it changes a little bit between the asylum office and the immigration court. So make sure you check the Pro Bono manual. But generally it's best to always follow the immigration court practice manual. It is fairly easy to follow and will have most of the answers that you need as to filing requirements, timing, and that sort of thing. Make sure you annotate every part of your index. As Anisha mentioned, we will give you a running start on that, but you should really tailor the country conditions and the index to your case, annotate it according to your case, and add all of the corroborating evidence and all of the primary evidence that you have to that index, and also annotate. So for instance, if you have a country conditions expert, their report may be 8 pages, it may be 20, right? So if you can annotate that in the index, that's going to make it a lot easier for the judge to look at what you're trying to get at with that report. We do side tabs, alphabetical side tabs on the original filing. And the filing requirements as to where you're going to file it, I think that depends on which court you're before or the asylum office, right? So that varies a little bit. I think generally you want to talk to your point of contact to make sure that we're following the procedures that are being used at that point. And with that, I'm going to pause for questions to see if there are any questions specific to this section. Let's see here. Okay, so I'm looking at the questions. I may have missed something, but I don't see any questions specific to this section. So I'm going to turn it over to Michelle to take over the next section.
Okay, thank you, Tanya. Hi, everyone. My name again is Michelle, and I'm the Pro Bono Project Coordinator at NIJC. In the first part of the training, we went over some of the terminology that the LGBT community uses. And then today we'll be going more in depth about how to represent an LGBT individual.
Michelle, I think you might be muted.
Yes, I'm sorry. Okay.
That's okay. You stopped right after you changed the next slide, then it muted for some reason. So you can start from there.
I'm sorry about that. Okay, so in the first part of the training, we emphasized the importance of being aware of LGBT terminology and taking a step in familiarizing yourself with these terms in order to make your client feel comfortable and safe as you work on their case. We mentioned that it's best to avoid using words that may potentially hurt your client. At the end of the day, your client chooses how to identify, and you will need to respect that by using the name they choose to use or using the pronouns they identify with. When you aren't sure of a word or term that your client uses, or if you simply do not know the meaning, it's important that you ask, but with intention and respect. And then the last thing would be that when mistakes happen, and they will happen, it's okay. And here again, we have the gender unicorn. It shows the differences between gender identity, gender expression, sex, and physical and emotional attraction. If you notice, gender identity, gender expression, all of these are exist on a spectrum, not a binary. Also to note that for some of these qualities can shift and move on that same spectrum. Something to flag is that you must be flexible and open to changes people may have regarding their sexual orientation and gender identity. There are also some clients that will come out as trans after we've begun working with them, so it's good to give them that space to be open with you if their feelings about their gender or their sexual orientation change over time. So next we have some examples of cues that you can take from your client when they communicate identity terms, pronouns, or preferred names to you. For example, if a client tells you that they are lesbian or gay, you will not reply and call them homosexual. You should stick to the terms they use to identify themselves. If your client is trans, it's important to ask them their name or the name they prefer to use. Refrain from using the client's legal name when you are talking to them directly. Even though you will be required to use your client's legal name in, for example, any government applications, we think that however, that when you are speaking to them, it's always best to use their preferred name in order to make them feel comfortable. Also, if you don't know what pronouns to use, just ask. Make it a habit to check in with your client regularly about this, and if the pronouns or name you're using to address them are still okay. And also, it's important to be open to your client changing their preferred name or pronouns throughout your work on their case. Again, this is just a reminder to keep up with terminology in the LGBT queer community. There's always something being updated or terms that are changing. So in order to prepare yourself to do a better job at building a safe space for your client, we recommend checking out these links. And we will also let you know in the end of the presentation how you can access this webinar later. When we work with LGBT individuals from other countries, we must also keep in mind that terms in the American LGBT queer community may not be internationally accepted or may not be used in the home countries of your clients. Some countries still use derogatory terms to address folks from the LGBT community. So be sure to accommodate differences also when you're writing your brief. For example, a Spanish-speaking client may identify as homosexual. We've seen this being used with Spanish speakers mostly, but we would not write that in our brief and instead would write gay or lesbian or however appropriate. Another example is that people still use the word travesti in Spanish to refer to transgender individuals, but it translates to transvestite. In this situation, you should recognize that referring to your client as transgender in your brief is the way to go rather than use the word transvestite. Remember that our own perceptions of what an LGBT person is or is not may not be the same in every country. For instance, they may be reserved or private about their sexual orientation or gender identity. Also, the movement towards gender, using more gender inclusive vocabulary is discussed everywhere, including many of the countries our clients come from. For example, in Spanish, the use of ella, ellas, or the at symbol, or the X instead of using an O or an A at the end of a word is being discussed. And these are steps to use gender neutral words and to avoid gender specific nouns when making generic references to both men and women in order to make language more inclusive and LGBT and queer friendly. And last, it may not be something our clients are aware of, but we should be at least familiar with the fact that gender neutral pronouns are out there and are being used by many people across many languages. So we believe that applying these following rules will make for a better experience when representing an LGBT individual. First is familiarizing yourself with terminology again in English and in any other language you will be speaking to clients, like for example, Spanish, will help in normalizing the process and allowing the client to feel comfortable speaking to you. Recognize that when you ask a client about their sexual or romantic history, keep in mind that their country dating culture is likely very different, and same-sex dating is probably completely taboo. Just because someone hasn't had open relationships in the past, that doesn't mean that they don't identify as gay, lesbian, or queer. And then the same goes, of course, for gender identity. Just because a person hasn't had the opportunity to pursue gender affirming medical care, that still doesn't mean that they might not want to do so. And last, many people are curious when it comes to trans bodies, but it is many times not relevant for you to ask questions in regards to body parts. Always ask yourself, why am I asking this question? Do I need to ask it? If needed, in order to better advocate for a client, then be sure to tell them that. Many trans people are used to people asking them intrusive questions, and you want to make sure you know that you are not asking because you're just curious. And to finish off this section, we wanted to bring up the topic of representing detained LGBT clients. Representing detained clients will look differently, and you may find yourself putting in extra energy and time to build a strong relationship with your client more than you find yourself doing while representing a non-detained client. For example, communicating with your detained client may be difficult. Depending on the detention center they are at, you will need to figure out how to make legal calls to your client. Some detention centers have strict lunch or dinner hours or lockdown times. Some are in different time zones that you might be. Some only accept faxes to set up calls, and others require emailing an officer or a phone call to schedule a call and a different call with your client. Unfortunately, other detention centers do not even allow your client to be in a private phone room and must make calls in an open area where other detainees can listen to them. So they may not feel comfortable sharing all of their experiences of harm, or may not feel comfortable telling you about their sexual orientation while detained with other individuals around them. Many detained LGBT folks are scared of getting outed and potentially being physically or even sexually abused inside the detention center. So you will need to have patience with your client if they need more time to open up to you, especially about certain past harm. Something else to flag is that gathering evidence for your detained client may be more difficult than with a non-detained client, and that's because detained clients get their phones and all their belongings taken away when they are officially detained by ICE, DHS, and this can make it difficult to reach family or friends of the client. It's important to know that using the correct gender pronouns and addressing your client by their preferred name is really important in this context. Your client may be misgendered or addressed by a name they aren't comfortable with inside the detention center they are in. So to use the exact same words your client uses to identify themselves, you are acknowledging your client's autonomy in self-identifying their sexual orientation and gender identity, and that is powerful. Just two more last things for here are that throughout the case of a detained client, checking in on detention conditions is good to do. It is also good to check in with your client about where they are housed. For example, if they are in a trans-specific unit or housed according to their gender assigned at birth, or in solitary, asking your client if they are receiving medical care and if you need to advocate for them to receive hormones or adequate HIV care. And then going back to asking where they are currently placed in the detention center. If they are in solitary, it will be important to track how long they have been there too, for mental health reasons. And last, it's important to keep track of your client's mental health or physical health and/or physical health in general in order to know any changing symptoms or medications throughout the case. Clients, again, may require you to advocate for them when it comes to obtaining these medical services or medications from the detention center they're at. So that was the end of my section, and now we will turn it to Alicia.
Great, thank you, Michelle. So this is our last section of the day. I hope everyone's hanging in there. This will be a brief section on how to present your case, whether that be at the asylum office or in front of an immigration court. It is fairly short because how you present your case depends heavily on the type of case you have, the judge you have, if your case is defensive, and when your case is moving forward. And so much of that is case specific. So we don't find it useful to go into too much depth in this part. But you should, check out our manual, which is attached. We really do walk you through the step by step. And then, of course, we're always here to chat with you about your individual case, to explain further what is maybe not explained in the manual or in this presentation. Next slide. So I know that this slide was already discussed on Tuesday, but just really quickly, want to make sure that that we address this, that depending on the track your client is in, if they're affirmatively filing or if they're defensive posture, the agencies you are going to be in contact with are a little bit different, right? So it is really important that you are acquainted with the different agencies, as it really affects the different forms you will fill out, as Tanya mentioned. If you're filing in your appearance with the asylum office, you want to file a G28, while in immigration court, you want to file an E28. The difference is slight, but it is really important because in order to obtain certain documents, you're going to need to fill these forms out, right? You want to be sure that you know when your court hearing is or when it's changed and things like that. And so you do definitely need to file the correct forms at the correct agencies. It is also just really helpful to know that these different agencies, as your client will have encountered a number of them once they have entered the United States. It is incredibly confusing. And as I mentioned before, it is important to speak with your client about the roles, who you are, who you are not, how you relate to the governmental entities that they have interacted with in the past, and so forth. I believe Tanya went over that a little bit about, what role you play, what role your clients play in this whole system. But I just wanted to briefly orient us to this again. Next slide. So the big thing to keep in mind here is that if you are in immigration court in particular, and to some extent, if you are at the asylum office, but really in immigration court, this is a real adversarial trial. So it isn't as strict, meaning many rules don't apply, like the federal rules of evidence, for example, don't technically apply. Judges can do a lot more of what they want, and so can government attorneys. But the real takeaway is that this is a real adversarial trial. You need to be prepared for that, and you need to prepare your client for it as well. And it's not necessarily going to be a great feeling environment or experience, especially for our LGBT clients with court proceedings, often outside of Chicago, but sometimes even here. We see a lot of, ignorance in the way that judges and the government attorneys act, and it can be really, disrespectful. And our job as attorneys, as advocates, is to know when to push back and when not to, right? And when, which is again something that we are always happy to chat with you about. It does depend on your case specifically, of course. So here, you see on the slide the affirmative and defensive processes. The affirmative process should be non-adversarial, generally speaking, and generally speaking, it is, right? It is. It's not a court setting, but depending on who your officer is, it sometimes can feel a little bit more hostile. So that's just something to keep in mind. But so no matter where you are in the process, you need to be prepared for that, for adversarial or hostile kind of environment. So the first thing you will do is file your G28, as Tanya mentioned, and the Form I-589 to the Nebraska Service Center, and this is in the affirmative track, right? Usually after the client receives a fingerprint notice, after the client files the application, they'll receive a fingerprint notice, and then the interview is scheduled. We'll talk a little bit in a minute about the timing around that. The officer has one of two possible decisions to make. As you can see, they can grant, and then your client is on the road to becoming a permanent resident and eventually, hopefully, a citizen, or they could refer the case to the immigration court, and then that places your client in court proceedings. This puts them in a same posture as someone who is in defensive proceedings, right? Because now they will be in defensive proceedings. I should note here that there is a third possibility for those who are in some other type of status, such as a student. So if at the time of a decision by the asylum officer, the client is still in lawful separate kind of status, like a student, the officer, instead of referring the case, would deny the case. And that would mean the client wouldn't be put in proceedings because they are in some lawful status. So the government has no right to remove them. That's as long as the student or your client remains in and adheres to their student visa rules. And then they can apply for asylum again affirmatively if wanted. And that's the reasons behind why they would do that or not are separate kind of conversation. And then again, moving to the defensive process, it is a trial, it is a courtroom setting, and that is what you need, again, to be prepared for. Apart from someone who was referred to the immigration court by an asylum officer, other ways someone would be in defensive process is through the way in which they came into the country, right? So sometimes they are apprehended at a port of entry, whether that be at the northern or southern borders or at an airport, or sometimes that means that they entered, they may have entered the country and didn't encounter immigration officials and then were picked up later for whatever reasons, whether that be a traffic violation or another type of criminal case. And then, that's how they enter into proceedings. They will be issued a notice to appear, which is, as Tanya mentioned earlier, like a charging document, which places them into immigration proceedings, and then they are told to show up for court at what we call a master calendar hearing, which is like a status hearing, where the client is going to go before the court and can do one of or more of the following. One being they can ask for a continuance because they're not prepared, or they could be able to plead to the notice to appear, the NTA, often admitting that they were not here with legal status, but that they have a defense to removal, which is that they cannot return to their country because they're eligible for asylum. And if possible, filing the Form I-589, or if previously done, informing the court that the application was on file. In order to move outside of master calendar hearings or towards merits hearings, both the NTA has to be pled to and the I-589 needs to be on file. The judge, if those two things have been completed, then the judge will set it for a merits hearing, which is, as I mentioned before, is like a trial, right? Where you will be doing a direct and the government attorney will be doing a cross, and we'll get into that a little bit more in a minute. And it's just important to remember that in both the affirmative and defensive processes, the Form I-589 application for asylum and withholding of removal is the same. This form is what proves whether an application was filed. So it is, again, really important that it was filed timely, right? So it's really important that this document get to the appropriate agency on time. Next slide. So, in terms of timing, first we'll start with the asylum office. This is a little bit up in the air because prior to COVID, the asylum office timing was fairly predictable for cases filed after 2018. If you have a client who has not yet filed for asylum, we previously could and believe we will be able to again in the relatively near future predict what the timing will be for their cases. Our advice around preparation is going to still be the same. Since the asylum office moves fairly fast for cases filed post 2018, and we assume they will be doing that again, you need to prepare your case as much as possible prior to filing that Form I-589, as you probably have about 4 weeks before the interview will be scheduled, and with only a 2-week heads up about the date and time. And again, right now the asylum office timing is off by quite a bit from this chart. Due to the pandemic, things have slowed down, but we are being told that they will resume the current policy of last in, first out, this post 2018 policy. And the AO has, the asylum office has informed us that they are opening and scheduling interviews. I personally have not seen any interviews scheduled, and we're still working with them around, ensuring safety and health of clients, attorneys, and interpreters. As they have told us, I guess the process that they're going to be doing, at least in the Chicago asylum office, is by video. So meaning of one officer, the officer will be in one room while the client, attorneys, and if needed, interpreter will be in another. So things are just even more unpredictable in the immigration court process, which we'll be talking about in a minute. What is really important to understand is that we are dealing with a system that is dysfunctional and often unpredictable. So it is important that you are managing your client's expectations for that dysfunction, around that dysfunction, right? Because we often see that clients see this broken system and then wonder why their attorneys with, what they feel like is a lot of power are unable to move their case along. And so it can create kind of a breakdown, right, in your relationship when you are unable to move things along. But so it's just really important to constantly be managing your client's expectations for this full fact that it is, fundamentally we're, kind of in a broken system right now, and a lot of unpredictability. So next slide. So at the immigration court, things are even more unpredictable, but in very different ways. As you can see, the number of individuals who are in removal or deportation proceedings has drastically increased in the last few years, and it has just created, just a really clear picture of what we, could call a bottleneck. So you see more and more money being given to Homeland Security for enforcement, right? And so more people are being arrested and placed into removal proceedings, but you're not seeing that equivalency or that equivalent number of, increase in funds to the Department of Justice to ensure that there's enough judges to adjudicate these cases. So you also have an administration, that is making policy decisions on how judges should manage their docket. So those are things to just kind of keep in mind. For example, saying that, they want to expedite certain types of cases, let's say, because they're a priority for removal. So what they have been doing right now is, in past administrations really is kind of prioritizing recently arrived families, right, who are seeking asylum. They're using it as a deterrent mechanism, thinking that it will, that if they quickly deport these families from Central America, right, that it will deter others. But this is a ridiculous proposition because you can't just deter someone from coming to the US when they are fleeing for their lives. But this is what they're doing. So just to keep in mind. So when that happens, you see judges having to focus or prioritize family cases and then pushing back cases that were scheduled during upcoming hearings, such as I had a client from Uganda who entered in 2012, and he just kept on getting pushed. He just got asylum in 2019, and his case was kept on being pushed because around priorities, right? So it's just good to know that information. Always coming to us asking for that kind of intel as your case is approaching, right? As your hearing is approaching. So overall, we're dealing with an unprecedented issues with the asylum office and immigration court. The important takeaway is that filing that I-589 timely is crucial. We are staying on top of the information about reopening and coming, out of both, that is coming out both out of the asylum office and the immigration court. So, but it's still really important that we, still manage those expectations of clients and understand that the system is in a lot of ways falling apart. And so, a lot of this is out of our control, and you just have to keep that in mind when we're talking to clients. Next slide. So if you have these delays, what should you do about it, essentially, is this next part. And so I know Tanya went through some of this already, but the most important thing is to maintain contact with your client from that very first meeting, right? You have to have that communication in place that includes regular calls. I would say monthly calls for the non-detained individuals, even if there's nothing going on in your case, you need to check in with them, see if contact information has changed, see if other things have changed in their lives. And if you get a hearing notice and you need to contact your client, you need to know how to do that. So keeping regular contact is so crucial. Beyond that, you can also, you have a lot of time to prepare your case. So, our suggestion is, regardless of when your hearing is, regardless of when we think your asylum interview may be, doing everything in the beginning is, ensures you're in the best position possible. So completing those affidavits, getting a good start on your brief, getting those, corroborating documents together, and then whenever, closer to your interview or merits, you can just update them or supplement them, right? So we see that, some pro bonos will maybe leave things till the end, and they don't realize how much time it takes that you need to put in for these cases. So, just making sure that you're working on those affidavits, especially as witnesses, become unavailable potentially, or your client's memory, becomes less good. It's just really important that you get those facts down early. And then working on, getting witness declarations can take time, and recollections may be different, right, than the client. So between the client and the witness. So you just want to make sure you have you're giving yourself the time, if you have it, right, to make sure that, you're clearing out any kind of discrepancies that may arise. And other evidence, as mentioned, is also important. If you have the time, we can help you with connecting, with therapists, with a forensic or psychological evaluation. That's just all really important. And if your client is in immigration proceedings, you have to, request biometric appointment. If client is before the asylum office, that will be taken care of by the asylum office, so you don't have to worry about that. However, if your client is in immigration proceedings, in immigration court, your client has to be printed by DHS, by the Department of Homeland Security, prior to the merits hearing, or the judge cannot issue a decision in the case. And if you haven't attempted to get an appointment, the judge technically can deny the case for abandonment. So it's just really important that you're trying. There are a lot of issues around trying to get biometrics appointments right now, where people are submitting requests and they're being ignored. And so you just want to keep pushing, okay? And the last point I'll make on this slide is, employment authorization. It's really critical. What is important here is that you are calendaring when your client is eligible to apply and when they need to renew. Because we often see situations where, clients come to a pro bono and say, my work authorization is about to expire, it is going to expire, and they don't realize that renewals cost $410 and that they take time. And so, you just want to make sure that you're on top of it, helping your client along with that situation, especially because, oftentimes it depends on, the lack of work authorization can affect their ability to support themselves. And, there is, unfortunately, our asylum, before I say this, the asylum manual has clear instructions on how to apply, and so please do look at that. But lastly, there are changes that are coming in August, and we will have more about that on our website soon, so you know how to prepare for your client for this. They are going to be quite drastic for asylum seekers, and so it is specifically around the work authorization. So it's really important that you know the changes once they are implemented. This is separate and apart from the asylum regulations that have come out. This is specifically about work authorization, and it's just good to know that stuff. So moving forward. Okay, so there is actually a little bit more to go through. If people can stay for an extra 10 minutes, that would be great. If not, completely understandable. So we are going to touch briefly on how to prepare your client for the asylum interview or merits hearing, but our asylum manual does go into more detail, and we're happy, of course, to talk about individual cases. Very broadly, we strongly recommend and utilize this ourselves, this 3-part kind of prep method. The first being a session where you fully prepare the client. You really walk through with your client thoroughly what is going to be asked of them, why they are being asked, and what the judge needs to understand, right? So explaining all the elements to your client, asking your client your direct examination questions, and then stopping your client and explaining what they said was good, but maybe they want to, the judge wants to hear X, Y, or Z. So, trying to work with your client on how to answer the questions the best way. It's also important to note here that, the asylum officer will be asking the questions. So, they will be more open-ended questions like, why did you come to the United States, or why are you applying for asylum? And then they'll build off the responses. So it's really important that you prepare your clients for those first couple of questions, especially, and so that they can be prepared for that kind of open-ended way of doing things. But while, in the immigration court, if, it will be you asking those questions, and you can tailor your direct to ensure that the client gets out their full story in a clear way, right? Also important to prepare your clients for interruptions by a judge, and this will, vary from judge to judge. We can also help with providing common questions asked in the asylum office, and by providing a sample direct if your case is before the immigration court. That second prep session is really, a more tougher one. I think specifically for the immigration court proceedings, this is important, is to do kind of a mock cross-examination, and you should try and make it a little bit tougher than what you anticipate it being like. And that's just because, credibility is going to be one of the main things that the government attorney is going to focus on. So the level of preparedness and toughness you hear from the government attorney is going to differ dramatically, but you need to prepare, right, your client to be heavily cross-examined, especially on credibility. And then that third prep session is just a confidence builder. You really don't need, suggest doing prep on the day of. So making sure you do that before. And so whether you are at the asylum office or an immigration court, you want to prepare your client for the type of interview or hearing they're going to be at, right? So your client is at the asylum office. You want to make sure they understand what it will look like. That image there is what it usually looks like. As I mentioned before, it's probably going to look very different. And so making sure that you talk to us, that you learn about what it's going to be like, and then relaying that information to your client. The same thing with the immigration court. You'll want to explain the setup and how things where everyone will be seated, and when questions will be asked and all of that. And then one of the most important things for prep is to make sure your client understands what needs to be proven in the case and how you see the facts of your client's case fitting in with that, right? So you want your client to understand that we need to show that they suffered, right, harm rising to the level of persecution. We need to show that why the government, couldn't control or stop and protect that, your client from the person who was trying or did harm them. We need to show why your client was harmed, and we need to know that the reason your client was harmed is because of something that your client can't change, right? And based on that, you have to and then you can say, like, based on what you have told me, meaning you, the client, I think you have, been persecuted because of X, Y, and Z. I think that the government couldn't control the person who harmed you because of X, Y, and Z. I think based on what you have told me, the reason you were harmed is because, for example, you're gay or you're transgender, right? So you want to make sure that you explain those things to them, and you want to make sure that they know, what they have to prove or what you are trying to prove on their behalf, because if they don't understand, the government attorney will try to, turn things on its head a little bit for them. They won't, if they don't understand why the government attorneys may be asking, well, isn't it true, everyone in your country deals with violence. There's a lot of generalized violence, and your client's like, yeah, there's a lot of generalized violence. But really what you want them to say is, yeah, there's generalized violence, but particularly to me, I, as a transgender woman, is being harmed, at a higher level, or whatever they, you guys end up discussing how to answer a question like that. Again, managing expectations and possible results. So if at the asylum office, explaining that they could win or be referred to immigration court, which is, again, okay, because it is a second bite at the apple, we will go, and, if that happens, we'll go to the immigration court. And, finally, make sure to empower your client. Anytime they do not understand a question, they should say, I don't understand. Can you repeat the question? Or if they don't know the answer, make sure they know that they should not guess, right? They should just say, I don't know, right? If they think they know the answer, you want them to say, I think, or I believe, right? Just don't have them guessing. Next slide. So yay, the asylum office, let's say, grants your case, and you want to please immediately let us know so that we can help with next steps, including time-sensitive benefits that they will now be eligible for. If your client is not granted asylum, they are going to be referred to immigration court again. Like I said, not the end of the world. It's a second bite at the apple. We will move forward and talk about the best way to prepare for the case, keeping in mind that there might be delays at this point. Next slide. After the merits hearing, right, same thing. If your client is granted asylum and the government does not reserve appeal, the decision is final. Your client is an asylee. Let us know right away, right? And we'll talk next steps. If the client gets granted asylum and the government reserves appeal, they have 30 days to decide if they are actually going to file an appeal. What that means is that we have to wait 30 days to see if they're going to appeal. If they don't appeal, the decision is final and the client is an asylee. If they do appeal, then we have to see what the BIA says, right? Likewise, if the judge denies asylum, you will reserve appeal, and we will have 30 days to file a notice to appeal, and then some months later, we'll get a briefing schedule. And just note, you have an automatic right to appeal the immigration judge's decision. So that means that if you lose at the immigration court level, the decision is not final, the removal order is not final until it is affirmed by the BIA. So your client cannot be deported during this time, and it is extremely unlikely that they will be detained unless there is some other sort of outstanding issue around crimes. This is in the non-detained context, of course. And then just a couple more things. Next slide. Really quickly, I'm so sorry, I know we're going off time. Specific to detained cases, court proceedings, but this is relevant for non-detained as well. This is a good chart to understand the process depending on the type of case, whether that be an asylum or in a withholding of removal or a CAT case, protection under the Convention Against Torture case. Again, making sure to go over these potential scenarios before court with your client. Detained clients are often fixated, understandably, on release, and so it's important that they understand that even if they win asylum, withholding, or CAT, they may need to stay detained depending on the type of case, right? Whether the government reserves or waives appeal. And one practice pointer is that if you are granted any of these three types of relief and the government attorney does reserve appeal, you should take the opportunity at that time at the hearing to ask them when they believe they'll have a decision on whether or not they're appealing, and the best way to contact them so that you can move things along. In Chicago, the government attorneys often just reserve appeal but don't end up appealing because they have to get supervisory approval of waiving appeal. So it is a way to move the release of your client along, right? Especially if the government ends up not appealing but doesn't exactly inform ICE about that at the appropriate time. And last, if your client is detained, you must work on a release plan, which often includes housing, transportation to wherever they're going to live, healthcare services. These are really important things, and it also preps the client for release. Next slide. So I just want to thank you all for joining us in this presentation. I hope you will consider taking a case. If you you can find our pro bono list on our website or by emailing Michelle. If you are unable to answer your questions during this time, please reach out to Michelle and we'll get those questions answered. This webinar recording will be available within the next few days on our website. And then lastly, we really value your feedback, so you can hold your phone up to this QR code and complete the brief survey, or complete it once you receive it via email. We really would appreciate that feedback. Thank you so much.